Just on that point, we're talking about the problem of insiders and so on. One of the pieces of research that we looked at for this presentation was the Carnegie Mellon Institute's CERT guide, which is called the Common Sense Guide to Mitigating Insider Threats, 19 Best Practices. And I think it's well worth reading. I didn't bother printing it off because it is about 170 pages. But the Common Sense Guide to Mitigating Insider Threats. And it just looks at 19 key practical guides that you can put into place. Everything from clearly documenting existing enforcement policies and so on. But it also has a little chart at the top of each policy which indicates who needs to be involved, whether it's the HR department or the legal department or so on. So if you've got a chance to have a look at that, you can Google it. I think they're up to about their 4th edition. I wanted to touch on this idea of accidental breach, and I'm sure all of us have inadvertently sent an email to the wrong person. You've had the Outlook thing where it puts in the name for you and you just hit send, or you've hit reply all. That has a often embarrassing effect in the day-to-day world, but when it comes to a data breach, it can actually have a much broader effect. And one of the cases that we looked at was the Earthquake Commission out of New Zealand, so somewhere relatively close to home. This case where an employee of the Earthquake Commission inadvertently sent some details of about 98,000 claims to an individual who was representing 10 of those claimants. And it's a question of ethics, really. Initially he said, that's fine, I understand you sent it in error, I'll delete it. And then he said, oh, actually, they're my clients, I owe them a duty of care, I'm going to use it. So my question for the panel on this is, where do we draw the line? We've received some information. I think, Heather, you'll probably have a legal ethics view on this that you probably have to delete it. But if information falls into our hands, Stephen, can we use it?
It's a very interesting question, and I'm sure Heather will be able to talk about some of the case law that may serve to exclude information as evidence if you're relying on it to take a particular course of action. But I think if you're going to maintain the reputation of an organisation and your reputation with your client, and the reputation that you have even with those whom you might be adversaries with, even if it's just on a competitive basis, you have to stand up, you have to take a stand and provide some leadership. And whilst it's impossible to unknow information once you've seen it, personally, there's an obligation to protect it and not use it, and to let the person know over whom you might have some advantage that, look, this has come into my possession. How much should you read? Should you only read enough to understand that is it privileged information?
So you take the ethical position ahead of the best interests of your clients.
Yeah. Do you want to subsequently expose yourself to misusing information that may have been illegally sourced by someone else? Was the person who sent it to you, were they committing an offence by releasing information over which they had disclosure obligations, or even if it was accidental? Where do you put yourself and your client ultimately? If it may be a fairly hollow victory if you use that information, but you were relying on information that was sourced illegally or from someone who committed a crime by releasing it,
or may have even been wrong.
Yeah,
it might not be factual.
Yeah. Do you know that the information is true?
Heather, have you got an opinion on this?
I think it's always interesting when you see companies that have a disclaimer at the foot of the email that says, if you got this by accident, please delete it. I don't know if that creates a contract between the end user and the person who sent it. I'd argue that there is no contract, there's no consideration. You didn't ask to be sent it. I actually don't think that, when you look at the common law principles around confidentiality, and it usually is in the case of trade secrets and intellectual property theft and those sorts of things, where they say if something was imparted in circumstances where you knew to keep it confidential, or there was an agreement in place to keep it confidential, there's all sorts of tests. It doesn't really cover what happens when you come across the information quite innocently because somebody accidentally leaked it to you. That's just actually really not, to my knowledge, covered explicitly. In fact, you know, if from an IP case, there's certainly, you know, somebody got the pattern and copied the sweater and knit the same sweater. Well, that's a clear infringement. Somebody else just happened to knit the sweater that looked the same. You know, there's no infringement. It's complicated in terms of was there any intent, etc. And I actually think that in this case, if you get information that you didn't ask for, and sorry, the third example there is where somebody goes out and buys the pattern or has come across that information in a legitimate sense. So I think in this case, that, you know, if I got information, there's no privilege because, you know, it's not between a solicitor and a client. That's the test for privilege. You know, unless the communication, well, no, because it's not between the lawyer and the client. So.
What about two opposing sides in a litigation, lawyer to lawyer? If they accident.
Well, then there's the, you know, there's the law society rules of professional conduct.
Yep.
So between two solicitors, and that's a different matter.
Yeah, it's delayed.
But in, you know, if I got an email from somebody inadvertently, and I thought I could use it to benefit my client, yeah, I'd probably go ahead and.
Right. Yeah. Okay.
There was an incident a few weeks ago where an organisation were going through thinking about an announcement of the resignation of the CEO and the number of the directors. And the CEO accidentally emailed the correspondence between himself and head of HR in regards to the wording of the announcement letter to all of the staff. And then that email was deleted, withdrawn. But that information is definitely market sensitive.
But does the individual receiving that have a duty? I mean, if it's an employee of the company, you'd have a duty to your employer, potentially, right? A duty to potentially some sort of, you know, there's
also potentially an investor.
Right, so if you're
a shareholder of the company.
Right, I think if you're an employee, most employment contracts will talk about, you know, there's some catch-all clauses about doing the right thing in the right interest of your company. You can be sacked if you don't, that kind of thing. Because really, but I come back to it. You know, if you get an email, this is my view. I think the law supports. If you get an email inadvertently, morally, what you do with it is a different question. And if it's between two lawyers, there's rules, codes of conduct, and you can be disbarred and the rest of it. But you know, if you get information that you didn't ask for, it's not like you went out and said, "Oh, if you get anything juicy, send it to me." You know, you haven't induced some sort of breach. You've just inadvertently, quite innocently, received this information. You're entitled to use it.
It's a bit like walking when you've nicked it through to the keeper, but the umpire's given you not out.
Jeffrey, what happens when this sort of stuff hits the media? Either the New Zealand case or
the New Zealand case is an interesting one.
Yeah.
And I think, for me, look, yes, there are legal frameworks. Should I do it, should I not? But I'm more intrigued about what is this information that he's got? If it is so sensitive, does that mean that the Earthquake Commission has done the wrong thing? Are they holding back information? And that then goes to the heart of, for me, the issue, which is around, can I trust these people? They are looking after the welfare of not just the 96,000 victims of the Christchurch quake, but the Earthquake Commission is a statutory body, and earthquakes happen all over New Zealand, so it's massive, and it's a fairly well-trusted body. So when I look at a breach like this, I think, and when I'm talking to clients and about it, I say, well, what's the panic? What are people actually concerned about? The average punter, and I know mainstream media is where it matters because they're the ones that read the papers or whatever and make the decisions and vote. So for me, it's around the mainstream. It's not about the informed, intelligent people. They're looking at the mainstream and they're saying, wow, I don't trust this Earthquake Commission. What's going on? Is that something that could bring the government down because there is so much heat there? So if you look at how they handled it, I think they handled it very well because the story went out of the cycle straight away. What happened was they came completely clean. They said, this is what's happened. All the facts. We sent an email, inadvertently sent an email, had this data in it, we've done it, we're sorry, we shouldn't have happened. Here are the safeguards we normally have. Here's what we're doing in future. We've spoken to the man, he's agreed to give it back. We've actually, I think they took out an injunction to make that happen. So it was kind of, oops, accidents happen, that's okay. But now, Brian, if Mr. Staples, if he turns around and tries to use that data, he's the bad guy. So there's an interesting play there. Is there something that he shouldn't have had because the Commission is trying to suppress data, which is sort of not in the interest of their stakeholders? And then there's the idea of how do they turn it from being the idiots that made the mistake, putting the media's heat on him, to being the bastard who uses the data.
Yeah,
It's an
sure.
interesting play.
Yeah.
It seems to me that what we're talking about all the time, each of you is attracted in a different way, but we're talking about the friction between what is moral and what is legal. And I don't think any of you have given me the answer that most businesses or most citizens would come up with necessarily. There's no indicators there which way to go. If I take this track, that's the way I go. If I take that track. What's your comments?
I think that you're asking for a black and white answer and something which is great. I don't think there is a right or a wrong. And yes, we're all coming in from different perspectives. And for me, it's around how do you express your version of the truth? How do you bring the public with you? Or how do you react when there is outrage? But I think that that in terms of trying to find a program or an algorithm that will give you the right answer, it's just never going to happen. Never going to happen.
In the Snowden case, I think I answered that I think it's treason. I think that the facts will support that. And so whether he had good reason and whether it was in the public interest, I think he'll still fail the test at a legal level. And in relation to the earthquake matter, I think I've answered that, you know, if you receive an email, if you receive information, if you come into it quite innocently, it's yours to do with it. You have no contractual obligation to anybody to keep it private. Even if you're an investor, you don't have a duty to the other shareholders. There's no, you know, in the broad circumstances, there's no obligation. You're free to do with it. You know, morally, what you choose to do as an individual, and what a judge might say, well, you know, I take a bit of a dim view here. Strictly speaking, you know, there's no common law breach of confidentiality that's taking place. I think you're free to use that information. So, you know, I'm not familiar with. I haven't actually read the reasons for the injunction being granted. So,
yeah.
So I haven't read those reasons so I can't comment on it.
From my own experience, I can tell you from working in Halliburton that they took a certain approach to these sort of things. And you may recall that in 2003, 4, 5 and 6, they were never far off the front page. And a certain Senator Waxman in the United States Senate worked very hard to ensure that that's where they stayed. The view that I saw inside the company was one that was entirely different. That, you know, all of the bad actions that had occurred had been self-disclosed. Now they went, you know, some might say overboard. I saw it as a great moral strength within the company to do the right thing, even to the extent where it may disadvantage the company. And they were fighting so-called battles on many fronts. There was the billing to the US Army Corps of Engineers who were paying their bills in the Middle East, to the extent that, you know, if we can't support it with the paper trail evidence, then we just won't bill. We're going to swallow it up, even though our profit was only on 2%, and they were restricted to 2% and 1% on many of the things. On the case of all of the claims and indeed class action that was being mounted by their families and those that have been injured in the course of their duty in the Middle East, against the advice of some of their corporate lawyers, they were making full disclosure on all information, that even that which could damage their defence of the case, to ensure that at no time ever in the future, should this information ever come out, could they ever be accused of withholding information even if it wasn't favourable. So there was a very clear intent on data retention, information retention and ethical behaviour that everybody not just had to abide by, we had to sign up to it, we had to go through the training. And every presentation given by managers at every level, including the chief executive officers, started with safety, and then they talked about doing the right thing. And so that was a framework within which that company operated and management operated, so that if ever you were faced with a dilemma, do the right thing. And what's the right thing? What's the front page test on this? And that's where they took it. So I think they got some very savvy media advice early on to ensure that they didn't ever expose themselves to a charge of not doing the right thing.
I'm talking about the court of public opinion, and we're talking about the law courts. And I think your point, Stephen, to me what I heard was, even if you win the battle, the victory in the law courts, and we get Snowden and we crucify him, he is hung, drawn and quartered and vilified as a whatever, that's not going to make the American government look good. That won't get the president re-elected or the next candidate re-elected. So we're talking about different things. Court of public opinion, court of law.
Great, thank you. Well, look, we will move on. I've got a couple more things that we want to discuss. I might bunch the next two. So the first one is around physical security, and this is a case from Australia. The Institute of Company Directors loses a PC out of the National Australia Bank building next door that happened to have all the data of their membership. So 66,000 records of presumably Australia's top executives, all on the one laptop that was just laying around somewhere, and somebody picked it up and walked out with it. Stephen, what can we do to protect the physical assets?
Well, there's a whole range of things that you ought to do, but at the end of it, it comes down to the investment of that marginal dollar in physical security or behaviour related cultural training. And my view at the end of the process is always that you get a better return for every dollar you spend on training people and working with them to build trust than you do from the marginal cost of the extra physical security. That doesn't mean you don't focus on that.
I mean, should this have ever been on a laptop?
So it should never have been put there in the first place. So you have that range of reasonable physical security measures in place. And if you can't afford the intrusion prevention, then you at least have intrusion detection, and you build those up and you test. But you've got to have clear policies about how you treat information. You've got to classify information within an organisation, and that means having a document records and management process and policies, even if you don't have the full document and record management systems. All firms would. Managing matter management is dear to the heart of many people I know. Having filters on who can see and who can't see, compartmentalising data, that's not an information, so that only those who need to see it actually have access to it. But companies don't do that, and if they have the policies, they tend not to enforce it because it takes time to get them in place. Having simple information classification systems rather than complex ones also makes it easier. Ensuring that people sign up to a policy, getting someone to actually sign a piece of paper rather than just telling them or advising them, read this policy. Getting them to actually sign something, I commit to protecting the information and the non-disclosure of information that I may come into and not to access information I'm not entitled to. That actually, I think, sets a trigger in people's minds that
sets the tone for the culture of the organisation.
A committing signature on a piece of paper that says I will not do this or I will abide by that, and it makes a difference. And if you lead from the top and lead from the front on this, that it is about leadership and showing that you mean what you say around protecting information. Follow procedures from the back rooms in IT about how you set up test environments and the operational environments. You never put live data on test systems. You create an air gap around machines which hold very sensitive data. Just as we have a safe with a combination lock, you have to have the same mentality when it comes to digitally stored information.
Absolutely.
So, procedures, policies, getting people's commitment, and classifying information, and making sure people are aware.
Yeah, absolutely. Heather, I've been down to Macquarie Telecom, and it'd be very hard to get in there without some sort of security check and so on. But I think, Geoffrey, you raised the issue about bring your own device. Heather, within Macquarie Telecom, can people walk in with their iPhone and walk out with data, or how do you stop that?
There's a difference between our head office, where people like, I sit there, like my CFO, etc., and our data centers. So data centers where we store data, they're a bit like bunkers now. They're kind of, there's no signage. Actually, we don't want people necessarily to know what it is. And there's tri-factor identification. So there's something we have, which is a pass, something that's part of you, like we do kind of biometric thumbprint, and something, so there's some signatures, it's all those sorts of things, with security, bulletproof glass, etc. Because we're storing, emails for the Prime Minister and Cabinet and the like. We do have work, federal government customers in our data centers. So it's that level of security. So you can't really, come in.
You can't even get through the gate without, actually showing your ID.
Yeah, you have to show your ID and all the rest of it. But I think in the office, where there's, HR records and it's not our customer information so much as it is our company information, there's still an escort policy. There's still, you get issued a badge. Still, could somebody bring in an iPhone and take a photo of something? Yes, those sorts of things can happen. Of course, we've got everything wrapped around policies, similar to the sorts of things Stephen talked about. But you can't sort of follow people around all day. We don't glue the USB ports.
Maybe after Snowden you might. Geoffrey, what does this do to the AICD brand?
Well, I think the AICD brand has come away reasonably unscathed from all of this. It's an interesting one because, again, here they're the innocent victims, they're the victims of crime. Yes, you could say they didn't have enough security, but if you look at it, what they didn't do was blame the NAB, which was the primary cause of failure. What happened was there was building works, power failure, some reason like that, in their landlord, caused by their landlord, which meant their front door popped open. So somebody came in and took a laptop. So if they had then blamed NAB and brought that into the forefront, that would have been a massive debate that would have kept it in the media attention, kept it focused. But they didn't. They let it go. And in fact, it only really made the IT section, which is interesting. Because real people don't read that anyway. But the way the AICD handled it, again, is really good insight into how we can manage these breaches, which will happen. Again, they came very clear about what had been lost, what had been taken, and they put it into context. They worked really hard to downplay it. They said that the information was there, yes, 66,000 records, but it was nothing that wasn't on the public record. There was nothing confidential. They talked about the fact that there were 3 layers of security to get into the data anyway. And really, in my take out of it was a chancellor who stumbled across an open door, pinched a laptop, not a set top. So it wasn't actually a data theft, it was an equipment theft. Probably had taken it down to the pub and sold it 5 minutes later for $50. They couldn't obviously say that, but the way they talked about their processes and their policies didn't involve any blame, kept it really clean, made it move through the cycle really quickly, and made them look good, as good as you can be.
Might just move on to sort of talk a little bit about hacking. I've got a couple of topics left, so hopefully we can get through this one. David Irvine, our Director General of ASIO, recently was quoted as saying that a single malicious algorithm could turn off the lights, stop aeroplanes flying, disrupt national financial transaction networks or the electricity grid. And I've actually heard him speak on this next case as well, the BHP Billiton case out of Canada. BHP Billiton was involved in the purchase or the attempted purchase of a $38 billion potash company out of Canada. There was concerns from other people that this might not be the best thing for BHP to control the global supply of potash. And there's some accusations, and I don't know how founded they are, that some Chinese hackers were actually targeting the law firms involved in this deal. Now, the deal fell over for other reasons, but it's an interesting one where it was sort of widely reported that Chinese government hackers were after law firms who were working on this deal. Are we sitting ducks for this sort of stuff, Stephen? Is this where government and corporate collide and suddenly we've got the power of the military to start hacking?
Most of the attacks on firms are by externals. Over 90% of hacking is from external, and a third of those are from state-sponsored agencies.
Right, a third.
China, Bulgaria, Eastern European, United States, Russia account for over 80% of all of those. So it's going to happen. Most companies are subjected to hundreds of probes every day. If they have the standard firewall and other multi-layered security protections in place, most of those won't get through. Those that do and those that are successful, again, come down to user behaviour. And it is how they treat the unsolicited email. If you don't recognise the sender of the email or the company, then don't touch it. Most of these succeed because somebody clicks on an email, which opens malicious software which propagates within the system. But even then, that malicious software can only work if you don't have compartmentalised data that is protected through encryption, and other people are making a range of mistakes in handling information. So it requires a whole causal chain of events for these attacks to be successful. And if any one of those filters or barriers is up, a lot of which are around behaviour and following procedures and classifying information, etc., then you are going to succeed in preventing it.
And where we're involving external parties who may end up being the weakest link, can we impose certain security requirements on them?
Absolutely. It's your company. You are in the driving seat as to what the rules are for doing business with us or engaging with us or coming into our corporate home. Here are the rules of behaviour.
Yeah. And Heather, we've seen the Australian government recently come out with some information about a move to promote cloud for within government. I know that it's only sort of recent, so I don't want to go into too much depth on it, but do you think that this is something that's been thoroughly considered?
Well, I think it has been thoroughly considered. I've been part of a number of sort of task force committees that the government sat on over the last couple of years. This is, right. I would say they're not early, sort of fast adopters. It's taken a long process to get them comfortable with the cloud. And I think from the government's perspective, there's a few different things that they look at, what the types of data. So if it's the Premier's Reading Challenge, I don't really care if my son's reading list, maybe it's not as long as your son's reading list, but I don't really care if it gets out. If you compare that sort of level of information with the defence, for example, requirements of the cabinet, emails, those kinds of things, and there needs to be, I think, a different framework that is looked at in terms of where that data is stored. And I think that the government's position, certainly I've spoken to a number of ministers about this, is that for those types of highly secure data, a number of them take the view that they do want that data stored in Australia because at least they know where it's located. And there's really tight regimes around access. And there are technological ways of dealing with denial of service attacks and those types of things, as Stephen would no doubt be familiar with. And so I think that there'll be a red, amber, green analysis that applies. So if the data is green, they may not care if it goes in the global cloud. If it's red, then there's a whole different framework.
Geoffrey, just looking at cyber attacks and hacking and the duty to sort of disclose, or as you said, the advice is to disclose, is that different if it's a hack as opposed to an accidental data breach?
Well, the way you handle it obviously depends very much on the offence that's actually been caused, whether you've done something wrong, whether someone else has done something wrong. But again, let me come back to the big picture here. It's what's at stake? What's the reputational risk? What are people panicking about? What are they worried about? And I have a phrase, pick the panic. Find out what, don't focus on the events, focus on the fear. So when you look at the fear, how can you allay those fears? And the good news is it comes back to all of the policies and procedures we've just discussed. When you are communicating, be open about what are your policies, what are your procedures, where was the weak link, how, was that reasonable, what have you learned from that, and how have you changed? So I think one of the things I notice that companies tend to overlook when they're racing to work out what can we say in times of crisis, whether it's about a data breach or an oil spill, the media are interested in actions, the public are interested in actions. You've got a lot of information. Share it. Be upfront. That's what you do.
Okay. Last topic to discuss is modern technology and where we can go with it. I love this photo, so I just had to share it with you. Recently, a group of privacy commissioners came out and penned an open letter to Google outlining their concerns with Google Glass. And obviously there's been quite a bit of discussion about Google Glass, the idea that you can be wearing this technology, you've not only got access to all sorts of information, but you can be taking photos, you can be taking video as you're wearing this tool. Geoffrey, perhaps I'll start with you. What's the purpose of an open letter, and is it because Google wouldn't listen to them independently?
Well, an open letter is a classic publicity ploy, really. It means nothing. What they are doing is making a big dramatic statement to Google that they are concerned. What is more interesting to me about the open letter is the number of signatories. The fact that they could get 26 countries. Something like that, yeah. Diverse countries. So what that is saying to me is sending a clear message that, hey guys, this is on our agenda. We are looking at this. We're focusing on this. You're going to get the big media hit when the letter goes out. I always think they're a complete waste of time. But there is a clear message out of that. You may get a media hit if they respond because you're going to mail them the letter as well. That's the courtesy. And if you look at what what also happened in that, the US Bipartisan Committee on Privacy, I think it was, followed up with their own open letter about 2 weeks later, asking basically the same questions. And they got the response. They got a mailed response, which was inadequate. So what does it do? It's a really handy gimmick to get some attention. But this battle, if you're serious, is going to be won or lost in social media, not in mainstream media. The only way you can stop Google Glasses, and already there's a competitor coming to market shortly at $300 a pop. The only way you can stop Google Glasses is by getting buyers to not buy them. And I think, frankly, it's a lost cause. I mean, it's going to.
And do you think that this is a way for the regulators to sort of cover themselves and say, you know, once this data breach happens, they can say, look back to our open letter, we told you this might happen?
Well, actually, Hal, I'm going to throw you on that one because we had an interesting conversation at the start about law always having to lag technology.
Yeah, I think that's right. I mean, if you look back to the copyright reforms in the Digital Millennium Copyright Act, I mean, you know, piracy used to be, you know, the sort of thing that only really, you know, anyway, certain people would engage. You know, I used to I ran some of the post-Napster litigation against Kazan and effectively shut them down. Sorry, but in the new digital age, you know, copyright infringement is like your child up in their room downloading, you know, videos before the changes around personal use and that sort of thing. So my point is that up until a certain point in time, the ability to prosecute under the Copyright Act didn't kind of mirror, I guess, the technological advances that we enjoy now, and it lags behind. So this is another example where, you know, if the question is, do the national privacy principles protect Australians in relation to this, I think that probably as we see these types of technologies continue to evolve, the law will have to be sort of amended to kind of address those things. And it's a bit of you don't know what you don't know until these things start selling and how they're being used and abused. And then the law catches up and tries to address those situations. Right now, there's, you know, I don't even know what you do with these things.
Yeah. And Stephen, is that the same in business? Can we prevent our employees from posing a risk by bringing in new technologies, or do we have to wait until we see a fall and catch up after that?
I think it's a bit of both, and it's like the law lagging on this. Attempts in the past to introduce legislation or change the law to prevent some yet to be defined threat have rarely succeeded. The internet browsing nanny software that was proposed by the Australian Parliament, fizzled out very quickly because the unintended consequences and the difficulty of policing it made it ridiculous. Why invest in it? So as these issues actually arise, I recall the same predictions being made when smartphones first started fielding their cameras and the ability to text and MMS photos instantly and videos around the globe, and what's come of that. I don't know of any legislation that's specifically directed at that effort, except the focus is on protecting people's privacy.
So we're going to have to play catch up, aren't we?
But I think it's an exercise in futility to try and preempt the way this is going to go.
Thank you. I'm going to bring up a last quote, which I'd like to leave you with, which is before the PRISM program really kicked off. from the National Intelligence Service of the US. Too often privacy has been equated with anonymity, and it's an idea that is deeply rooted in American culture. We need to move beyond that construct and ensure that anonymity and privacy, with privacy, and focus more on how we can protect essential privacy in this interconnected environment. And I think that's sort of a great quote to leave us with. Thank you very much for this morning. I found it really fascinating, and I hope the rest of you have as well.